Hi everyone, my name is Lena Nguyen. I'm a family law attorney licensed in Texas and California. Today we're going to be talking about arbitration. Arbitration is one of the various methods of alternative dispute resolution, and it's also often referred to as ADR for short. So the idea behind alternative dispute resolution is exactly what the name entails. Rather than solving disputes through a lengthy trial process, the dispute is actually streamlined through a process that will save time and money and will hopefully help the parties resolve their issues. Arbitration is like a mini trial. Arbitration clauses are often found in contracts and agreements, and they do show up in family law. So here are 6 reasons some parties choose to handle their family law matters through arbitration. Number 1, you choose the decision maker. The parties and their attorneys present their case to a hired impartial third party who is also known as the arbitrator, and this person is agreed upon in advance. The arbitrator is the decision maker and essentially serves like a judge. He or she will render specific awards after hearing both parties present evidence. The court will then render an order that reflects whatever it is that the arbitrator has awarded them, unless there are clauses in the award that goes against the best interest of the child or the children. Oftentimes, parties will hire retired judges to serve as arbitrators. In family law, retired family law judges are often hired due to their decision-making experience and expertise in family law. Number 2, you get to decide the rules. Arbitration is a voluntary process. The parties and their respective attorneys can set rules regarding how the arbitration process will be conducted. So rather than following the rules of civil procedure that is mandated by states for parties in litigation such as family law cases, the parties are in control of every aspect of the arbitration process. The parties can agree on the trial date before the arbitration, the length of discovery limitations, and any other agreement that's necessary to help them facilitate an agreement. Essentially, the parties have free control to tailor the procedure to better suit their case. Number 3, you get to establish appeal rights. One of the facets of the arbitration process is that the parties can agree upon appeal rights. An appeals process is when one party makes a formal request to change the official decision that is rendered. So for instance, some cases will go all the way through trial, and then the judge will render a verdict, and then one party won't like it, and they'll appeal their case. So the appeal will not only add to the cost of the case, but it also lengthens the entire process. The ability to limit the appeal rights will actually allow the parties to save money and time so that they can move on with their respective lives. Number 4, it allows for privacy. Arbitration is a private process. Anyone who is not a party to the case cannot attend any hearings or attend any proceedings in the arbitration process unless there is a consent between the parties and the arbitrator. Many public figures choose to arbitrate their divorce because it allows them to keep their personal lives private. Number 5, arbitration could be binding or non-binding. So parties can stipulate or come to an agreement on whether the arbitrator's ruling will be binding or non-binding on the parties. If arbitration is binding, the arbitrator's decision is final. If arbitration is non-binding, a party can request the court to render the final judgment. If a non-binding arbitration is chosen, the case will continue through the traditional legal route where the parties will present the case before a judge or a jury depending on their jurisdiction. There are advantages to choosing a binding arbitration as well as a non-binding arbitration. A binding arbitration can ensure the parties that they won't have to spend a lot of money on a full-blown trial, and they can control to an extent the amount of legal fees that will be expended in their case. Further, the parties have a more definite final date for their matter, since the parties can come to an agreement on an arbitration clause restricting an appeal. A non-binding arbitration can actually facilitate negotiation. So an arbitrator's decision can actually give the parties insight into how a judge or a jury may carry the weight of the evidence that is presented by the respective parties. With an arbitration rendition or order, the parties are more likely to reach a negotiated settlement because they're in a better position to actually weigh their options. Number 6, the parties can save on time and money. The purpose of arbitration and other alternative dispute resolution methods is to help the parties save time and money. Most family courts have such full dockets that they cannot easily schedule trials. Oftentimes, parties will have to wait over a year for the court to even hear their case. Also, because the parties decide how arbitration is going to be handled, as discussed before, the parties can make decisions ensuring legal costs are kept at a minimum. Thank you so much for watching. Please give this video a thumbs up and subscribe to my channel. Also, if you live in Texas and would like a free self-help divorce kit, please check the description box below to sign up.